Welcome to Ballantyne Law, clear, practical legal advice that works.
Hi, my name is Grace.
And my name is Steph, and we're both paralegals here at Ballantyne Law. We have both worked in the estate planning division during our time here, and we're going to talk about some estate planning, our procedures, and why it's important to do your estate planning. So Grace, did you want to start by talking about a couple of the options that we have for estate plans here at Ballantyne Law?
Yeah, sure. So at Ballantyne Law, we offer two standard estate planning options, the first being a conventional estate plan and the second being a testamentary trust estate plan.
The conventional estate plan that we offer really just includes a simple will, which is often called a mum and dad will, and that's where the assets are left to the beneficiaries in their own right, which is in comparison to a testamentary trust will, where the assets are left to a trust to be distributed to the beneficiaries by the trustee after the testator has died.
How do we establish what estate planning option would be suitable for the client?
So generally our most cost-effective option is for us to send out a questionnaire. And that really gives our clients the opportunity to provide all of their information and their instructions to us. They can really have a good think about who they would like to leave their estate to. They can give us information about who they may want to appoint as executors, the types of assets and liabilities that they may have as well. And that really gives us an opportunity to have a look at all of those circumstances and provide them with a recommendation. I mean, alternatively, sometimes we have clients come in for initial consultations. I'm sure you've been to a few of those if you want to maybe go through what we generally do in those consultations.
Absolutely. So usually for our initial consultations, we start off with a general overview of what people ideally would like to happen to their estate, which might seem like a simple question at the start, but once you ask the question, it does tend to be that people don't really know what they would like to happen to their assets. Next, we would generally, again, establish what that asset pool is so that we can determine what plan might be suitable for them. Asset pool is not the only thing that matters in determining whether or not a testamentary trust will would be suitable. Family dynamics is another big one, either split families or just complicated family scenarios in general. So we go through the personal circumstances and background as well of the client. Next, after we've established what their assets are, we might establish who they would like to leave their assets to and who they would like to have control of their estate, so their executor. Once we have determined who the possible beneficiaries will be and who will handle the estate once the client has passed, we can formulate a bit more of a specific plan from there and maybe give them a rough outline or recommendation of how we propose that they proceed.
Yeah, I think it is important as well, whether or not we see a client for an initial consultation or if they opt to fill out the questionnaire, we can really give a good understanding of what our recommendations are and our fees going forward. As you know, we offer fixed fees for our estate plan, so that can be a real comfort to clients who are getting something done that they have been putting off for a little while. It's nice to know what they're heading into from the start. What are the advantages of testamentary trust wills?
Okay, so there's several advantages of a testamentary trust will. One, and probably the one that people focus on the most, would be asset protection. So under a testamentary trust, you can protect your assets from essentially an attack from third parties. It helps in relationship breakdown scenarios as well if your beneficiary does go through a family court matter or similar.
With beneficiaries who may be a little less conscious with their money or...
Of course, yes, absolutely. If you're concerned that your beneficiary, as you said, might not be quite responsible or spend their inheritance wisely, you may want to look at a testamentary trust option there. There are taxation benefits as well to a testamentary trust depending on the size of your asset pool, and that's something that we always recommend that you speak to your accountant or your financial planner about as well. Flexibility is another big one for testamentary trusts. So again, you can customise the trust and how it's administered and operated to your family situation and dynamic, which again just allows people a little bit more control over what happens after they have passed. In terms of the estate planning options that we offer here, do they include any other documents other than the will? No
matter what option clients like to take up, whether it's a conventional plan or a testamentary trust plan, we always recommend that clients also complete an enduring power of attorney, which is really a document that is important within the lifespan of the client. While the will might take care of your estates after you've passed away, if you are to lose capacity while you're still alive, it's important to have an enduring power of attorney in place so that you can have an attorney appointed to look after your financial and personal decisions while you are still alive. We do include those with both of our estate plans, whether it's conventional or testamentary trust. It's often something that clients don't really think about until you raise it with them. You know, who's going to look after your financial decisions, even if while you're still alive and if you don't have capacity. There's also options for general powers of attorney if there are businesses that are being run by the clients.
So a general power of attorney may be useful, as you said, in the instance where you run a company or a business and you have a planned trip overseas, or you're not going to be able to attend to the business's needs for a certain amount of time. So you might want to specify a time period where someone else has the power to look after your business decisions for you. And that way you're not stuck in a position where you can't attend to things that need to be actioned. And you do have someone in place that has the legal capacity to be able to handle those decisions for you. So in terms of documents in our estate planning options, both options include a will and an enduring power of attorney. Is there any additional documents required for a testamentary trust estate plan?
Yeah, so when we're doing a testamentary trust, as that is a more complex estate plan, we do tend to find that clients like to complete a guidelines to administrators as well. What that document does is just set out what the client's wishes are for their estate after they pass away. And that's more in regards of looking after their children or looking after their businesses or handling certain assets. It can be a really nice a way for clients to work out what it is that they own and what their executors will need to do after they've passed away.
So it's essentially like an instruction sheet for your administrators of your estate so that they have a more detailed understanding of what you would have liked to happen with particular assets or your children, your business, things like that.
Exactly, yeah. It really gives the client an opportunity to provide information about looking after their children, how to deal with their assets after they die, which is kept separate to the will and can be updated a lot easier than it is to update the whole will in full. So we find that clients do tend to like to fill those out and keep them here with their wills.
A benefit, as you touched on too, is being able to update them separate to the will. The guidelines to administrators aren't legally binding, so that's the difference between your will and the guidelines is the instructions you provide in your will are legal instructions. However, what you put in your guidelines is more a wish and a guide to what you would like to happen.
And just to provide some assistance to your executors and your trustees in administering those testamentary trusts upon your passing, as well as looking after your children. Obviously, these things can change over time, so as your family grows or changes, you can always come back and update those guidelines and change however you may want your family to be looked after upon your passing. I think all in all, our processes here at Ballantyne Law are as really straightforward as we can make them, especially with those few options with questionnaires or coming in for initial consultation. And at the end of the day, estate plans are so important to have in place. You never know what might happen.
So if you don't have an estate plan in place or you're looking to update your existing estate plan, we highly recommend that you reach out to us here at Ballantyne Law. We can either issue you a no obligation questionnaire or have a chat before we start the process.
For more legal insight, subscribe or visit ballantyneLaw.com. We're here to help.